Ladies and gentlemen, are courts supposed to educate or preach and express personal opinion? The Supreme Court today answered that question. The court has taken suo moto cognizance of a Calcutta High Court judgment which had some very problematic and regressive observations. This while acquitting a man of raping a minor girl he was romantically involved with. The High Court on October 19th asked young girls to control their sexual urges and not give in to 2 minutes of pleasure, as she will be seen as a loser in the eyes of society. The Calcutta High Court did not stop there. The two-judge bench of the very same court observed that sexual urges are not normal and normative and that they are aroused upon some kind of action by either a man or a woman. Today, the Supreme Court fumed at these observations, terming them unwarranted and objectionable. The top court reminded the judges of the Calcutta High Court and that it's not their job, and this is what the Supreme Court said, this is not their job to express personal views or preach. Now, the matter pertains to a man having a sexual relationship with a minor girl he was involved with. While everything was consensual under the Indian law, even that is seen as a criminal offence. The man was convicted for kidnapping under the POSCO Act by a Sessions Court, which had sentenced him to 20 years in prison. But the Calcutta High Court stayed that order and then went ahead to give these moral lessons. Point is, they rightly stayed the order. The man didn't deserve to be put away in prison for 20 years when everything was consensual. It was their preaching that became problematic. Shilpi Jain is a lawyer of the Supreme Court joining us on the broadcast. Rahul Easwar is an activist. Shilpi Jain, can I please ask you, what was the Calcutta High Court even thinking when they made the remarks that they made? I mean, these are learned judges. These are judges who have vast experience and hear all sorts of cases. They should know their jobs well. Their job is to abjugate. Their job is not to preach, not to give a moral lecture to someone who's coming to you with a complaint.
Absolutely. I welcome the intervention of the Supreme Court, and whenever there is a suo moto cognizance taken, I think it's always a welcome move, because if both the parties choose not to appeal against the order or the judgment, it obtains finality. So the intervention of the Supreme Court, thank God for that intervention. This observation or the judgment of the Calcutta High Court is absolutely contrary to what has been the outlook of the courts in the recent past with regard to sexual relationships or romantic relationships, which have been very progressive. Live-in relationships have been legalized, adultery has been decriminalized, and this kind of an observation means you are nullifying the right of a woman to have consent. This goes back into the dark ages. It is taking us backwards. It's absolutely denying a woman the right to have any choice with regard to her body. It's so sexist, the remark, and it smacks of patriarchy. It's because even the judges are coming from within the society, and in terms of societal change with regard to women, I think we still have a long way to go, and thank God for the intervention of the Supreme Court. Now, with regard to, suppressing the desire, I think the courts must refrain from passing any kind of sermons on morality, because as far as morality is concerned, it is not that one size fits all. What's moral for one person may be immoral for another person. So the courts must remain absolutely out of the domain, and they have no business. Tomorrow a court may say that wearing a short skirt is immoral, whereas another court may say, yes, all women must wear a burqa. So morality is something which is very personal, and every person must be able to decide for himself or herself what is immoral or moral according to her own parameter.
Okay. Okay, but Shilpi Jain, here's the point. The Supreme Court, I don't think, had any problems with the judgment per se, because no 19-year-old should be sentenced to 20 years in prison for having a consensual sexual relationship with a 16-year-old or a 17-year-old. So in that sense, the Calcutta High Court wasn't wrong. That wasn't problematic. The judgment wasn't problematic. It was the observations and the moral lecture that was problematic. Rahul Joshi, I beg your pardon, Rahul Easwar, you're joining us on the broadcast. According to you, did the Calcutta High Court cross a line as far as its observations are concerned? Who asked them for this moral lecture? You know, a problem has been presented to you, and you take the right decision. You take the right decision by saying this man will not go to prison for 20 years. No one is disputing that. But where was the need for these moral lectures? Where is the need to tell adolescent girls, listen, don't give in to your sexual urges for 2 minutes of sexual pleasure because society will see you as a loser? ये कौन सी सदी की बात कर रहे हैं भाई?
Shreya, 2 points. One, I totally agree with you in saying that High Court rightly took a decision against the misuse of POCSO, which has been widely misused, and the guy should not be in jail for 20 years. That was an error in Session Court's judgment. Second, regarding the ethical or moral point, I'm absolutely sure High Court was thinking like a parent. Any parent, any senior in our family, any grandparent would have given the same advice. So why are we conflating, or why are we unnecessarily misunderstanding the good intentions of the High Court? I'm a conservative activist. I'm anti-progressive. I'm anti-liberal. I agree with these values, and there are a huge number of people who agree with the family values, who agree with the conservative values, and they are the people who give the same advice. See, the courts, they do have liberal judges and progressive judges. Nobody has a beef against them, but at the same point of time, conservative, value-oriented, family-oriented judges or people are majority of India. So any senior person would have given them the same advice, right? If we have a sister or we have a younger one, we would have given them the same advice. Wait till marriage, or have that ethics. No, don't fall for temptations. These are the things that is commonly told in family. So court rightly pointed out from a paternal instinct that this is the thing. But paternal instinct shouldn't be mistaken for patriarchy. Being paternal, having care for the girls or boys is not akin to, and please remember, they also gave a strict instruction that boys should also be given, treated how to respect a woman. Boys should be having value education. So they were thinking like a parent, a grandparent, a senior in the society, or an elder in the society, and we shouldn't stigmatize for being that. And this progressive liberal police,
but
just
Rahul,
like
the point is, the judge is not my grandfather. Rahul, the point is, the judge is not my grandfather.
Nobody is saying so.
It is not the judge's job to give me a moral lecture.
That's the point I disagree with, because judges have a responsibility to uphold the ethical framework of any nation, because we all know family is the basic unit of society. Without a society, law cannot exist. See, the whole progressive aspect, I differ with progressives, but I respect them. See, these progressives and liberals, they have a very different view regarding family, society, culture, values, sexuality. Let them have it. But there is a huge section of Indian people who are conservative, who believes that sex should be inside the family, who believes in monogamy. Why do you want to force the so-called progressive police on the people who believe in family structure, monogamy, having sexual restraint? Even in AIDS control in America, they believe in, you should abstain. The ABC policy says you should abstain. So conservative values shouldn't be demonized, shouldn't be stigmatized, shouldn't be pushed to the side corner because progressive policy is there.
Shilpi Jain, would you want to respond to that?
Yeah. See, the moment the judges make an observation in a legal judgment of a kind where they say that the woman will be a loser at the end of the day and she must suppress her sexual desires, in a manner they are interpreting the law to mean that even if she gives her consent, even if it's consensual sex, even that they are discouraging or kind of denying. It's a denial of consent. A woman after a certain age has a right to choose what relationship she wishes to have. And now in the recent past, the ambit of rape has been increased to include cases where if there is sex based on false promise to marry, that will be included in rape. So there is deception, the girl can take a call. It is her choice whether to have sex or not to have sex. But if they make an observation like she will be the loser at the end of the day, that is totally a sexist remark, according to me. Why the man will not be a loser? They are almost denying the woman the right to choose if she wishes to have a sexual relationship. It's entirely her prerogative. Now, as far as advising as parents is concerned,
Shilpi.
that is not the domain of the courts. They are not running churches. They are not running convents. The judgment, you see, just as judgments cannot be based on emotions, emotions have to be kept out of the courtroom. They are totally based on evidence within the four corners of law. Similarly, a judgment cannot be based on morality, because morality is something very, very personal
Rahul,
and very subjective. It
Just
has to
one
be judged by the...
See, well, I understood. Shilpi ma'am, just one humble point of difference. She is of the age 16 or 17, maybe studying in +1 or +2. What else would anybody tell her? You have to give into consent. And even if she give consent, the boy can again be in trouble. So it's very natural for anybody to, we shouldn't be, stigmatizing these judges for saying so. Please remember, anybody in their right senses will give the same advice to the 16-year-old, 17-year-old girl. Will we tell her, it is your total agreement, you can do whatever you want. She's under 18. So the whole idea of consent below the age of 18 is again a point of debate. Can she give consent by the age of 16?
So Rahul
Will that
Easwar,
be taken
you're
rightly?
saying the Supreme Court was wrong.
See,
Okay, I think you made your point. So, Rahul Easwar, what you're telling me is that the Supreme Court is wrong in pulling up the Calcutta High Court.
I'm not saying that. Supreme Court is too big for me to comment upon. I humbly diverge with Supreme Court as a conservative activist. We all know that Supreme Court has been towing a progressive liberal line, which we respect, but we disagree with. We means the entire conservative ecosystem disagrees. So we respect Supreme Court, but there is a difference in so-called being progressive. We are proudly conservative.
All right, we'll leave it there. This was a good discussion. Thank you very much, Shilpi Jain, for joining us. Thank you very much, Rahul Easwar. Moving on, ladies and gentlemen, to some stunning